Apologize for the delay. We just wanted to make sure that we got the AV portion of this wiretype because there are people that tune into these things and watch the live broadcast, so I didn't want to start without them being able to see the entirety of the presentation. So again, my apologies. We generally try to get in here and prepare a little bit earlier than we were able to today, just some other meetings that were taking place in this room. So in any case, without further ado, let's go ahead and get started. My name is Blake Bingham. I am the Assistant State Engineer for the Division of Water Rights over the General Adjudication Program. This is the public meeting for the East Murray Subdivision adjudication within the Utah Lake Jordan River General Adjudication. We'll kind of talk a little bit more about what that means, what the implications are with that. But before we do, just a real quick lay down some rules of engagement, just at any time, if there's a question you have, feel free to ask it. I know I have a slide in here for questions, but if there's a question that you think is applicable to the entire group or in general, feel free to raise your hand and I'll answer it. Also, I know that the notice you received had a summons, and sometimes the language in those summons isn't very clear, and to some it may seem like that summons required you to be at this public meeting here tonight. That's not the case. You're welcome to leave at any time. There's no obligation for you to be here. We hope you do stay. We think there's some important information, especially if you feel like you have interest in some water rights within the area in which you live and receive this notice. But again, you're not obligated to. And anytime, once your curiosity is satisfied throughout the night and you feel like, hey, I don't need to know anymore, feel free to stand up and make your way to the doors that you entered. You won't hurt anyone's feelings, and we certainly don't want to waste anyone's time if they feel like they don't need to be here tonight. So here's the agenda that we're going to cover. We're going to talk about what a general adjudication is. Some of that includes the proposed determination process. We'll talk about significant issues within this area, anticipated timeline. Again, I have questions. For the online viewers, if you have questions throughout the presentation, obviously there's no way for you to immediately ask those questions, but if you shoot me an email during the course of the presentation at that email address listed at the bottom there, highlighted in blue, I'll look at the email at the conclusion of the presentation and attempt to answer those questions for the benefit of the entire group and for those viewing online as well. If you fail to shoot that email to me in time, I'll still respond. It'll just be probably tomorrow or some other time. I'll check the email and shoot you a response back. This presentation is also being recorded. It's available on our YouTube channel to review, as well as the slide deck will be put on our website for you to review at your leisure as well. So let's go ahead and get going. So one thing that I like to do when we give this presentation is really kind of talk about water rights in general. You know, this is really about a water rights general adjudication, but a lot of people come here with a variety of understanding of what a water right is and what it is not. So we'll kind of break it down into Water Rights 101 initially, just to help everyone understand what we're talking about. So what is a water right? Well, a water right is really, it's the right to divert or remove from its natural source and beneficially use water. Typically, water rights are defined by 5 different characteristics. You have the nature of beneficial use, which is, what is the water right being used for? Is it being used to irrigate your pasture or your lawn? Is it being used to for domestic purposes inside your house, or is it used for stock watering purposes? So that's the biggest component of the water right, is the nature of beneficial use. The next component is a priority date, and that in essence tells us, or tells everyone, where you fall in line with respect to getting your water. In the western states, they operate off of this doctrine of priority, which we'll talk about a little bit later. In essence, it means if you got your water right first before someone else, that means you get your full share of water before that person. And so if you have an earlier priority date, that means you have a senior water right to water rights who have junior priority dates to that. Again, we'll talk a little bit more about the doctrine of priority and how it evolved here in a little bit. The third component is the quantity of water allowed to be diverted. And we measure that in we quantify that in 2 different measurements. First is through a flow rate. We measure that in cubic feet per second, or CFS. or by an annual volume measured in acre feet. So imagine a property that's 1 acre in area and a foot of water in depth. That's 1 acre foot, just as it sounds. And so that would be what's diverted over an annual or 1 year period. We also have a specified point of diversion, and that's in essence where the water is removed from the natural source. So that can be a well, it can be a head gate off of a stream, it can be a spring box. It's wherever the water is physically removed from the natural source and being moved to be beneficially used. And lastly, a place of beneficial use, which is exactly what it sounds like. That's where the water is being used. And we annotate that using the Public Land Survey system, which is kind of a system that may be unfamiliar to some, but maybe familiar to others. But in essence, measures what section and what portion of which section in the Public Land Survey system the water is being used. Again, kind of getting into the weeds, but that's something that is part of the water right. So a lot of the questions we receive when we first send these notices and these summons out is people call up and ask me, well, I don't know if I have a water right. And that's a legitimate question because in this part of the Salt Lake Valley, in some cases, people drilled wells for their domestic houses and then sold those houses. The people who came in and purchased those houses didn't know that there was a water right associated with it and didn't know that a well had a water right or anything to that effect. So typically what we tell people is, you can, if you have a well on your property, there's probably a water right associated with it. So a well may be evidence of a water right, but it's not necessarily. Also, other evidences of a water rights are irrigation ditches or head gates on your property. And so you look at those pictures at the bottom. Those are on left and right are some pictures of what typical wells, small domestic wells look like. And then you have a head gate there in the center. Then what we get often is people concerned about, well, I have shares in a water company, or, well, I'm connected to the municipal, I have a municipal water connection. Are those water rights? And it's a little bit tricky. So shares in a water company or an irrigation company aren't necessarily water rights. What you have is a share in that company, and then the company owns the water right in and of itself, all right? So the company, in this case, would be participating in this, but you as a shareholder of that company would be interested in the outcome, and you'd want to make sure that the company is participating. So you have water shares, which are share in the company, versus water rights, which are what the company owns and distributes to their shareholders, okay? And then obviously connections to a public water supplier, not water rights. That's just simply that public water supplier providing you a service connection. Now, that public water supplier, if it's a municipality or something, they do own water rights, which they divert water and treat it and then distribute it. But they are very engaged in this process. Most of the, if not all, the public water suppliers in the valley know what's going on and know how to protect their rights and in a way protect your service connection. So you can rest assured for the most part that the municipalities are aware of this, and we're working with them to navigate this process. Irrigation companies, it's kind of hit and miss, because a lot of these irrigation companies or water companies are they don't have a robust system of leadership. Some of them are, I like to say, operated out of the glove box of an old Chevy pickup truck, to say the least. But some of them have a board and president and are very familiar, and then some aren't. So we just encourage people who have shares in these companies to make sure that the board or the president is aware of this process and can protect the irrigation company's water rights, okay? And if you have any questions, feel free to come in and we'll help navigate that and make sure that everyone understands. So one thing that is important, I think, when talking about water rights and the general adjudication is providing a little bit of historical context so we understand why we're doing what we're doing and how we got to this place. So you'll forgive me if for a brief history lesson, I won't belabor the point, but it's important for people to understand because suddenly you get this notice or this summons and you wonder what the heck is going on? Why is the state engineer suing me? And you wonder what's precipitated this, when in reality it's been an evolution from before statehood to where we are now, and this is just one of the steps in that evolution with regard to determining the existing or the historic water rights and how people people are currently using them. So let's back up to 1847, and we're all familiar with the story about the advance party of Mormon pioneers who entered the valley and started diverting the waters of City Creek to soften the ground so they could get a late season crop in. And then Brigham Young, then they built the mall on it, of course. A year later, Brigham Young made kind of an interesting statement. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all of the people." And this is really a basic tenet of how water is viewed in this state, in that it's not owned by the state, it's not owned by people, it's owned by everyone. It's a public resource. And so when we talk about water in the state and water rights, really it's really owned by the state or the people of the state. The division of water rights just helps administer how that water is distributed based on those water rights. Well, between 1847 and 1850, what we now know as Utah was really a part of Mexico. Then it became kind of this quasi-ecclesiastical state of Deseret, and then finally it turned into the territory of Utah. But even through all this migration, the government remained church-centric. In essence, the LDS Church kind of filled that power vacuum because there wasn't really anything there. As a result of that, diversions were made generally on a communal basis. You know, they would send pioneers north and south, east and west, and establish these communities, and people would divert the water for the communal needs and for the immediate needs of the settlers. And the doctrine of priority really evolved out of this gradual settlement, in that the first settlers that did all the work of diverting the water, building the ditches and the canals and putting to beneficial use, they got the first priority, or the senior priority, or the primary priority on that. And then subsequent settlers who came along, well, the settlers still wanted to share, but they said, well, you haven't put as much work into it, so you're going to get a secondary right. So whatever we don't get, you can have. And so that's kind of how the initial doctrine of priority first got established. And then it kind of evolved with the mining priority of first in time, first in right. And that's kind of where we are today, with a hybrid system of this primary and secondary and full seniority water right concept that we have to this day. Well, because the church kind of filled that power vacuum, all the conflicts were settled through those ecclesiastical channels. You had bishops' courts would kind of act as local justice courts, and then you had the high council who would act as the appellate court. So if you didn't like what the bishop said, you would take it to the stake president and the high council, and they'd overrule the bishop or side with him. And so that's just how things were going, how things were ran, because that's what they had in place at the time. Well, fast forward to 1852, and the first Territorial Legislative Assembly, passed the first law that tried to remove that authority from the LDS Church and give it to the county courts. And they gave them the responsibility for distributing all the water rights and all the timber rights in the state. But Salt Lake County is really the only county that adopted that or followed it. And in truth, the county courts, they were all elected positions, so you can imagine who the people who were electing to those positions. They'd be the bishops and the stake president. So in essence, there wasn't really much of a change. Well, in 1877, out of a desire to kind of promote homesteading in the West, the Congress passed the Desert Land Act. And really what that did is it severed, there were some subsequent court cases from it, that severed title from the water from the land. Now back east, you had these things called riparian water rights, where if you owned land adjacent to a river, you could divert from the river. You had no problems. Now, they didn't have a lot of irrigation need back east because they had natural precipitation, so it wasn't a big deal. And so the riparian system worked. Well, out west, you can imagine if you wanted to homestead a parcel that was removed a long ways away from a water source, you had to divert from that water source, transfer a long distance, convey a long distance to wherever your land was. And part of the Homesteading Act, you were required to cultivate that area. So really what the Homestead Act, the some effect it had was it severed that concept that water belonged to the property that it was adjacent to. And it also delegated authority to the respective states or the territories for administering water rights. And we look back on that and we think, well, of course the states should have that ability. But if you think about, at the time, you still had the government land office, which was issuing patents for land. And so you might think, well, water would be the same way. Well, this in essence said, all right, states, you're on your own to figure out your own water law, figure out how you're going to distribute these water rights and distribute the sources within your own states or territories. Well, the whole concept of giving the courts the ability to administer the water rights really kind of fell apart because the courts are an adversarial system. You need someone to file a complaint, and then you have two parties or multiple parties who kind of fight it out. Well, so the court's not really a great way to administer water rights unless they come into controversy with each other. So they decide, well, maybe what we'll do is we'll have these county selectmen issue permits and give rights. Again, it was largely ignored, and I think it was even found unconstitutional because you had the executive branch who was administering property rights. And so, in essence, it was just ignored. As a result of that, confusion continued in spite of the best efforts of the Territorial Legislature or even the LDS Church. And the Church continued to administer and decree water rights. A common example I often cite is the 1879 High Council decision on the Spanish Fork River, which is, in essence, settled how the river was distributed among several different large companies, and that is still how that river is distributed to this day. There's been some subsequent decrees, but for the most part, that High Council decision is what shaped how that river was diverted. Well, we move into statehood, and there's actually a lot of controversy at the time of statehood that the state might come in and take everyone's water rights and say no one had a water right, and there was a movement afoot to do that. And so in an effort to avoid that issue altogether, they decided to punt with regard to water rights, and they only codified one thing in the state constitution, and it was in essence, Article 17 says that if you had a water right before Utah became a state, or if you were diverting water, you had a water right after. And in essence, it grandfathered everyone in who was already diverting water. And so in essence, it said, all existing rights to the use of any of the waters in the state for any useful or beneficial purpose are hereby recognized and confirmed. And that's all they said. They were completely silent. There was no other law how to distribute or administer or appropriate new water rights. They just kind of said, we'll deal with it later, and pushed it on down the road. Well, in 1897, the office of the state engineer was created, but his office was really only meant to map out the different sources. He really had no ability to appropriate new water rights. He still had to go and like the old-fashioned days, go stake your claim by the source and then go record that at the county courts or the county recorder or the post office. And again, those were largely ignored. I've only seen one or two of those actual claims that were filed in the county recorder's office, but they exist. There are just not very many of them. Well, in 1902, the United States Reclamation Service was created, and we now know them as the Bureau of Reclamation. They were established to reclaim the arid West, and they would go and build these large dams and big lakes and reservoirs. And it was really we look on them and we think, well, they're obviously for motorboating and all these types of fun things that we currently enjoy. But really what they were intended to do was to provide irrigation water to help homestead the arid West. But the Reclamation Service was reluctant to build any of these projects in a state that didn't have a comprehensive water law that accounted for these old grandfathered rights as well as for administering new water rights. And so they said, hey, unless you got some type of law, we're not going to build a project in your state. So it's no coincidence that 1 year later, Utah passed a comprehensive water law that allowed for both recording of all existing water rights, but appropriating new rights as well. Unfortunately, they still required the courts to do all the adjudicating of existing rights, but they failed to provide any funding for the courts to do this. And again, the courts are a terrible venue to really figure those things out. First of all, they don't have the expertise. Judges aren't hydrologists, they aren't engineers, they aren't agriculturalists. So to know how much water a certain parcel of land really needs is not really in their wheelhouse. Second of all, it's an adversarial venue, right? You need a plaintiff and you need a defendant. And unless you have those things, a judge isn't going to go out and actively administer water rights unless something comes before him, and then he can make a decision based on the facts and questions of law. And so it really didn't go anywhere. Well, in 1919, so about 15 years later, they finally got wise enough. They said, all right, the courts aren't doing anything to figure out these existing grandfathered rights. What we need to do is give the state engineer the authority to go out and do a survey, do a determination of what the water rights are, and then he can take that to the court and just say, all right, I've done all your work, judge. All you got to do is rule on it. And that's largely what we do today. So what the state engineer now does is does a proposed determination. You'll hear that term bantied about a little bit tonight. And then the court will then take a rule on it, and then people have an opportunity to object on that proposed determination. So that's largely how we still administer this adjudication. And then 1935, so if I can back up just a little bit, that first 1903 law, that was only for surface water. You needed, after 1903, you needed a water right to appropriate new surface waters. They still considered groundwater completely separate. So up until 1935, you could drill a well without a water right. Well, they finally figured out that whether it's surface water or groundwater, it's all the same water. And so they figured, well, in 1935, you need a water right now to drill a well. But there are a lot of wells in the Salt Lake Valley that were drilled prior to 1935 and were never made a record because they didn't need a water right. They just, hey, I have a house, so I'm going to drill a well. That's how I'm going to supply the water in my house. And there are probably people in this audience who have a well from that generation. So 1903, the law governing surface water. 1935, the law governing groundwater. So, prior to the enactment of that comprehensive water law, rights to use the water typically fell into a combination of 5 different categories. You had those that were decreed by ecclesiastical fiat, those that were filed for record at the county. You had some that were decreed by a court, and they typically involved limited parties. You had contracts or agreements, again, among limited parties that didn't involve the state. You just said, hey, I'll give you this water, in exchange you give me this water. Salt Lake City was known to do that quite often. They have these exchanges with people who had diverted the clean canyon water, and they said, hey, that canyon water looks really clean, looks really good, it's up high, we can use that to provide water to our constituents. What if we provide you the dirty, nasty Utah Lake water, which is you'll get a full supply throughout the summer, whereas your canyon supply kind of wanes off in August. We'll give you this water, which is good for irrigating, and we'll take your clean canyon water, we'll treat it, and we'll provide it as clean water. And there are a lot of irrigation companies that agreed to do those exchange agreements, and there may be some individuals in here who benefit from some of that Utah Lake water that comes down through that canal. And then you had those people that never filed a claim whatsoever because they were already grandfathered in. They were diverting surface water prior to 1903, or they're diverting groundwater prior to 1935. They had no reason to file a claim because they were grandfathered in. So we really had no record of them. As a result of that, there are a number of issues. First, there was no public record. There certainly was no consolidated public record where people could go to find out the status of water rights or what there was. Since there was no record, their over-appropriation was pretty common, meaning that there were more water rights issued than there were physically available in a stream or even in a groundwater source. And because water rights weren't defined, they ended up in controversy, people fighting over each other, and they had to be settled through the church channels or through the court decrees. So in his biennial report, the state engineer used to have to do this report every 2 years. And this is from 1901, 1902. Remember, the first comprehensive water law wasn't passed until 1903. He made this statement. He said, The definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record. So the theory was, back in 1901, 1902, hey, we will get a law for recording all these existing rights. And once we know all these existing rights, then we can start appropriating new rights. But you recall, up until 1919, nothing ever happened. And so they just decided, okay, forget that. We're just going to start appropriating new rights, and we'll figure out the existing rights as we go along. And so we have these kind of two parallel tracks, even to today, where you have the appropriations tract, where people are appropriating new water rights, and we have the adjudication tract, which are trying to determine these historic water rights and get a sense for what is exactly being used at that moment in time. So what is this general stream adjudication of which I speak? Well, first of all, as its name implies, it's an action in state district court. It binds all water users, including the state engineer, otherwise known as the Division of Water Rights. The executive director of the Division of Water Rights has this historic title as state engineer. It's governed by Title 73, Chapter 4 of the Utah Code. And the first general stream adjudications took place back in the 20s. You will recall 1919 is when they came up with the idea of the proposed determination. So 1920s, there was a huge depression going on. They needed to provide a lot of work for a lot of people. So they said, hey, we got a great idea. Why don't we put a lot of these people to work going out and doing these surveys in some of these basins, and we'll knock out some of these adjudications. So you have places like the Sevier River Basin, that kind of periwinkle colored blob there. That was done in the 20s. You even had the Weber River drainage, which was completed back in the 20s, or actually started in 1919, completed a decade later, and then the Virgin River. So you had these three areas that were initiated. And a lot of these other areas were initiated a lot later, some of them in the 50s, and there's a reason why 1952 is a magic number for general adjudications that we'll cover here shortly. But as you can see on the map of Utah, every area in Utah is under one of these general adjudications. Now, the East Murray Subdivision is actually a bite of the Utah Lake Jordan River adjudication, okay? And that was initiated back in 1936. Salt Lake City decided to sue a bunch of people on the Jordan River. There's a huge drought. People were taking water out of the Jordan River without a right. Salt Lake City took them to court, and the court said, oh, this involves more than just you and your rights. We're going to have to expand it to a general adjudication. So that's how it got turned into the Utah Lake Jordan River general adjudication. But it's been going on since 1936, and here we are today still working on it. The reason being that this is a really densely populated area of the state. There are a lot of water rights, and we're just kind of taking a bite at a time, doing a subdivision within the division, within the greater general adjudication. So we get a lot of questions, why are you doing this to us now? You know, why now? And the answer is, yeah, it's just your turn. We've kind of made our way up the valley, and now we're kind of making our way back down the valley, and we still have places in Utah County to take care of. So we're just happen to be in the East Murray Subdivision this time of year. You know, had you been here, you know, had you sold, or I guess 20 years ago, you wouldn't have had to worry about this. We were doing the west side of the valley, but today we're doing the east side. So why do we conduct general adjudications? You guys are kind of quiet. If there are any questions, usually what happens is one person asks a question, then the floodgates open. Everyone feels more comfortable asking questions. Honestly, if you have questions, feel free to fire away. I'm happy to try to answer them. So why do we conduct general adjudications? Well, we like to bring all these pre-statutory claims. These are all the grandfathered rights, all the guys that were diverting surface water prior to 1903, and all the guys and gals diverting groundwater prior to 1935. We want to make them come onto the record so we know where we stand as a state with regard to our water resources. So a general adjudication forces them to come forward and bring that claim forward. Otherwise, they risk being barred from ever asserting that claim and not having a water right. So that's one of the things that the general adjudication does. Another thing it does is it forces the federal government to file their Federal Reserve water rights. Now, Federal Reserve water rights is a whole nother presentation and take a whole nother hour, but I'll kind of give you the broad stroke, covering broad strokes. Back in the turn of the century, the Fort Belknap Indian Reservation up in Montana was set aside. the Indians, obviously Native Americans, were trying to become, the purpose of that reservation was to make them into kind of more agriculturally based people. Well, they couldn't do that without water, and so they tried to divert some water from the Milk River, and the state engineer of Montana, again, kind of the equivalent of what we have, the state engineer, said, sorry, all the settlers around the reservation have already appropriated the Milk River fully. There is no water to be diverted for your reservation. Obviously, that didn't sit well with them, so they took him to court. It went all the way to the Supreme Court, and the Supreme Court ruled that because Congress had set aside this reservation for a specific purpose, that there was an implied water right for the purpose of that reservation, and that water right had a priority date equal to the date of the reservation. And so that was subsequently applied to other types of federal reservations. And if you can think about other types of federal reservations, you think of national parks, national monuments, Forest Service, all these other types of things that Congress has set aside, or even the president has set aside, potentially have these Federal Reserve water rights. The problem with that is that the federal government isn't obligated to quantify those. They just say, we get what we get to satisfy what we need. And there was really no way for the settlers or the residents of the state to say, well, if you get what you get, how much does that leave us? And the settlers couldn't really sue the federal government because federal government enjoys this thing called federal sovereign immunity, right? You can't sue them unless they allow you to sue them, which is never going to happen in most cases. Well, Senator McCarran from Nevada back in 1952 didn't think that was very fair. He had Congress pass a law often called the McCarran Amendment, which in essence waived the federal government's sovereign immunity with respect to water rights general adjudication. Not only did it do that, it makes the federal government participate in state district court. And so we as a state can force the federal government to quantify their Federal Reserve water rights and take it to a court, and they have to do it within the state district court. And so this is really a unique function. So that's why 1952 is kind of a magical date for all those other adjudications, because the state of Utah said, heck, our state is owned, nearly 70% is owned by the federal government, right? We have all this Forest Service land above our points of diversion that we rely on. How do we know how much water the Forest Service or these other federal entities, such as the National Park Service, how much water they're holding on to? Well, we don't know that without forcing them to come to the table and quantifying those through the general adjudication. So it's an important aspect of water law, especially in the West, where so much land is owned by the federal government. Another reason why we do general adjudications, why it's important, is to prevent a multiplicity of suits. We don't want a lot of people suing each other over water rights. We just kind of want to get it done in one fell swoop. One thing that's a little bit more, probably the most controversial aspect of the general adjudication is this concept of use it or lose it. So in the arid West, most states have this law that if you don't use your water, you lose it. It goes to someone else who needs to use it, right? And so Utah's not alone in this. In the state of Utah, if you don't use your water right for 7 years, it's subject to forfeiture, meaning it just goes back to your sheet of paper gets taken out of that priority line, and the next person up gets to use that water. Now, that's just the paper. In reality, if you don't use your water, that water's being used by someone downstream, right? So the theory is, hey, people have become dependent on that water when you failed to use it for so long. And if you were to suddenly inject yourself right back into the mix, 7 or 10 or 20 or 50 years later, there's whole communities who have been established on that water that's been running down the stream. And so in an effort to avoid speculation and avoid monopolies, our forefathers developed this law to ensure that water was always being put to its most beneficial use, and those who would become reliant on it would have access to it. And those who would fail to use it, that there was an incentive to use it, to put it to beneficial use, rather than just stockpiling it and making a monopoly and then selling it to someone else. And so in Utah, we have a use it or lose it type law. If you don't use your water right in 7 years, it's subject to forfeiture. And general adjudication is one of those things that comes through and looks at that. If you haven't used your water right in the last 7 years, we probably recommend to the court that it be disallowed or that it be abandoned. Yes.
If you're part of the company, is that on an individual basis or is that the company?
That's a great question. So if you are a shareholder in an irrigation company, let's say this, so you own shares in the irrigation company. Well, it's the company that owns the water, right? So what we typically do, and we'll just say irrigation company because that's easy for me to quantify and explain. Say there's an irrigation company that irrigates 100 acres of property, and each shareholder, one share is worth 1 acre, right? So you have a share for 1 acre. So there's 100 shares in this company. So let's say if you're a shareholder for your 1 acre and you fail to irrigate, and so we come around and we only determine that that water right's being used for 99 acres, and you're the shareholder not irrigating your acre. What do we do? Well, what we do is we recommend to the court that the water right be trimmed down to 99 acres, and then we walk away. Now, what does the irrigation company do? Well, Utah law allows the irrigation company to go to that shareholder who failed to use his share and reduce his share in the company by a prorated amount. Okay? Yes, sir.
I've got a well on my property. I currently use it. I'm registered with the state engineer. I need to file a claim. Is that correct?
Yeah. So let me rephrase. I failed to rephrase your question for the purpose of the viewing audience. But so his question is: I have a well, I have a water right. This registered state engineer. I'm going to need to file a claim, correct? Yeah, absolutely. And we're going to get to that here in a little bit. Everyone who has a water right will be required to file a claim. Now I know that sounds laborious and bureaucratic of us. I promise you we'll make it as painless as possible. You come in, we will file the claim for you. As a matter of fact, if you own the water right, we will send you the claim form that's already filled out. All you need to do is sign it and turn it back into us. We try to make it as painless as possible. We understand, this isn't, people have better things to do in their life than deal with these types of interruptions, but we do try to make it seamless. But to answer your question succinctly, yes, you will need to file a claim. His question, can you e-file it with court? You can certainly e-file it with court, or you can just file it with us. Either way. You can just hand it in at the front desk. Yes, sir.
I represent a homeowners association.
Okay.
But some of the board members have changed. How do we update the records?
So this gentleman says he comes from a homeowners association. Some of the records have changed. How do we update the information? If the homeowners association owns the water right, which I presume is what you're describing, and that ownership information is listed on our records. There's a process called a report of conveyance that the homeowners association would want to do that would update our records with your ownership information. If it's simply just an address change, that's easy. That's something that we can do. You say we currently now are at this address as opposed to this address. Too easy. If it's an actual title update, meaning it was in this homeowners association name, now we've changed and now we're this homeowners association, we want the ownership to reflect that. That's a little bit more complicated. We just want the address change. That's easy. Just write to us, or there's a form. It is pretty straightforward. It's on our website. Yeah, and I can show you where that's at afterwards.
Back to this, do you have to use all of your allotted water on your CFM or your acreage?
So his question, going back to the irrigation company question, his question was, do you have to use all of your allotted water, whether that's the CFS or your acre foot amount? And so there's kind of two interesting components to that question. That first of all, when we go and we evaluate water rights, we're more concerned about the beneficial use than we are the CFS or the acre foot. Certainly those are components, but in Utah law, a water right, the basis, limit, and measure of a water right is its beneficial use, meaning we measure a water right in its beneficial use, in how many acres, how many dogs, how many ponies, how many houses. That's really the quantification to us. Now, a component of that is the flow rate and stuff. So we would measure how many acres is being used. So that may not be what the question you're asking. Let's get to the question you're asking. Do you need to use it all? I'd say you need to have used it all within the last 7 years for us to recognize it in its entirety. And so if you can demonstrate that, this year we didn't use it all, but last year we did, we are trust me, I know it doesn't sound this way. We're trying to lean as forward in the foxhole as we can, giving the water user the benefit of the doubt. We're not trying to catch people not using their water. We want to encourage people to use their water. And if there's obviously circumstances where, hey, we just weren't able to use it that year or whatever, the law is if it hasn't been used for the last 7 years, that's when forfeiture might apply. So
All of it one time.
yes, if you want to get down to the very, very peculiarities of the law, if you use it all within one time within the last 7 years, that is protected from forfeiture. Correct. Yes, ma'am. So her question is, how does it benefit the state if we overuse your water rights? I don't think it does benefit the state if you overuse your water rights. I think what the principle of a water right is you want to use your water right for the extent for which it was deemed, right, is granted. Because that water is going to get used one way or another down this. You might say you're conserving it, but I guarantee you the farmer down the stream isn't. He's going to use it. If the water's in the creek, he's going to divert it. So we can talk about conservation, but in the end of the day, there ain't a drop of water getting to the Great Salt Lake that isn't going to be beneficially used, even at the Great Salt Lake. And so yes, you would be forfeiting if you don't use it in its entirety. But keep in mind, I know it doesn't seem fair. The most fair, so here's what I always say, the most fair and equitable water rights law is everyone gets everything they need without any issues, right? Unfortunately, we have a limited resource. We have more demand than we have resource. And so the next equitable way to do that is to ensure that people who have a right are using that because, and if they don't use that, the people who have been using that and who have developed their entire communities or developed their farms on this water that's gone downstream because someone hasn't used it, have the opportunity to perpetuate using that. So that's, and I'm not really going to argue the philosophical merits of the law just because I'm not the one who created the law. And it's certainly a discussion worth having, probably not right now, but we can certainly talk about it. Again, it's not my law. It's the legislature's law, and it's been in place for, 100 years. But I understand that it's controversial to a lot of people. People who have property rights aren't used to this concept of that if you don't use it, you lose it. But keep in mind, the water, you own a water right. You don't own the water, right? You own the right to divert the water and to ensure the most beneficial use of that water. The theory was, hey, let's avoid people from monopolizing, let's avoid people from acquiring these water rights, not using them, and then exploiting people who need them. And so that was one of the reasons the use it or lose it law was instituted, 100 years ago. Yes, sir. So his question is, he's owned his property since 1998. He wasn't aware until maybe recently that he may have a water right. Has it already been forfeited? Well, I guess the answer to your question is, have you used, if you used your well without knowing you had a water right, then no, it hasn't. If you suddenly have discovered that you have a water right and there's no well and you haven't used the well for 7 years, then potentially it could be subject to that. So, yes, ma'am. So her question is, if you own a share in the ditch company, is that the same as the water right or is that different? It's different, right? Because you own a share in the company. The company owns the water rights, okay? You own like a timeshare. You get so much time on the ditch, right? But the company owns the water rights. Now, does that mean that you don't need to worry about this? No, because at the end of the day, we want to make sure that the company's water rights are protected. So you want to demonstrate that you're using that, and you want to make sure that whoever is responsible for filing a claim, the board of the irrigation company, that they participate in this process. It just won't require you physically to file a claim on your share. The company would need to file a claim on their water rights. Now, we have had people file claims on their shares, and we simply take them and we put them on the water rights file. It's not a big deal, but you know, I don't want people to feel like they're obligated to do something and go through this hassle if they're not really. The better effort is to make sure that the board or the president of the company is participating. Yes, sir.
But if they don't file that, then would it be to our advantage to have filed that?
So his question is, if they fail to file that, would it be to our advantage to file a claim? Sure. Sure, and you can come in and if you feel like the board's not being responsive and you want to make sure that that water right's protected, and so you want to file a claim on behalf of your share on that water just to protect it moving forward, people have done that as well. It's not a huge issue. Again, we just put it on the water rights file. Yes, sir. So his question is, do we maintain records or a list of these water companies, and do we have records that show what type of use those water companies have been engaged in over the years? So it's kind of a two-part question. Do we know these water companies exist? For the most part, we do, because they'll have water rights on our records, and they'll have a water right. We have a huge file room full of water rights, and they're probably owner of one of or two of them or multiple of them. And there's certainly a record on those folders of things that have occurred. But the irrigation companies aren't really in the business of reporting to us what they've done on an annual basis. And there's no need for them, and we don't want them to, right? So what ends up happening, people that file the claim, and then we send our teams out to go evaluate the claim and see how much acreage is still being irrigated, and say, yep, you got it, good to go. Drive on. So it's a great question. So if you have a share on the company and the company files a claim, do we come out and evaluate that? Yeah, we do. As part of the process, when a claim is filed, we'll go out. So if the irrigation company, the theoretical irrigation company of 100 acres files a claim on the 100 acres, we'll go and we'll look at our aerial imagery, and we'll go and review the claim in the field and map out the 100 acres or the 50 acres and the Walmart parking lot or something to that effect, and make our recommendation to the court. So even though you didn't file the claim, you're using the water on behalf of the company to justify the extent of the claim. So we would be coming out to look at that. Yes, sir. Sorry, I'll get to you, ma'am. I keep on missing her. Go ahead.
Worried about water not being used correctly and running down a ditch and going away. So they encourage people, and also subdivision being built, they encourage people not to do farming anymore. So got an acre of ground, but I don't take anything in the ditch. If my water share goes to the water company, I'm allowed so many winter gallons and so many summer gallons. I can also lease part of my shares to people who have historic drainage. Now, if I'm not using those leases, does that mean that I'm going to lose the chance to sell off?
So the question comes back to, what are we looking at when we evaluate a claim, really? We come out, if the irrigation company or the water company's water right is for so many acres of irrigation, so many head of stock, so many houses, whatever it may be, we come out and we see what it is currently being used for. If it falls short of what it's being used for, then we make a recommendation based on what it is being used for. So if it's not being used, if the leases aren't been actively being used, then that might constitute a shortfall that the company can't account for. And so that it would be a recommendation to the court, again, that the water right be reduced. Let me go, this lady's been over here. Mm-hmm. So it's a great question, great point. She works. She's off the Tanner ditch. She has some shares on it. How does she go about keeping that water? And you answered your own question. Start using it, right? So if we come out and we see beneficial use, we're not interested in being water rights CSI and digging through the history to figure out whether that started recently or not. Again, if we can promote people, get people to use their water in accordance with their rights, we're all for it. So just use your water. And if we come out and you're using it, too easy. So our question is, there's going to be some improvements on this ditch. They're going to put it in a culvert. Can we require them to put some type of diversion structure or some type of improvement to it? That's really outside my wheelhouse. I'm sure that would have to be negotiated with whatever easement or however the developer is working that. So I can't answer that. Yes, sir.
What exactly do you consider beneficial use? We are living by a little lake, and my main use of the water is recreation.
So his question is, what do we consider beneficial use? And he brings up the example that he lives by a lake and his use is recreational. Now, so are you saying that the lake is you're claiming as a water right? See, the lake's, it's just in its natural source, right? So there's no real water right for a lake because it's a lake. It's not really being pumped and irrigated. It's not being, yeah. So in that sense, you're still using, yeah, sure. I use Pine View, right? I go swimming in all the time, but I don't have a water right for it. It just exists. So no, you wouldn't have a recreational water right. Usually what a water right indicates is an actual physical removal from the source and application in some capacity, whether it be for irrigation, stock watering, domestic power generation, waterfowl habitat. I mean, there's all kinds of uses, but just because you're using the water doesn't mean you have a water right either, okay?
Having fish there, waterfowl.
Yeah, and you can certainly claim whatever you want, and we'll look at that claim and we'll say, disallowed, probably. I mean, we're not going to recognize a recreation water right. Again, a water right has to have some basis, whether it's been appropriated through the state engineer's office or it's been grandfathered. Just because you're using a water right for recreational purposes or you're fishing on a lake, there's no appropriative basis for that right. There's no historic pre-statutory basis for that right. You can certainly make the claim, but it's probably not something we would consider. Yes, sir. So yeah, that's a great question. So on that little frequently asked question, there's a map on the back, has a bunch of, I think they're purple dots. Those are all the points of diversion that we know, that we have record of. Okay, so those kind of represent the individual rights. And at the conclusion of this meeting, we have some aerial images outside in the hallway with a close-up of that so you can see your house and maybe zoom in a little bit closer on where these are to see if that maybe correlates. And also, I'll show you a web application that we have where you can zoom in right in on your dog house and see if you have a well underneath it or at least nearby. But let me tell you what, let me get through a couple slides and then we'll open it back up to questions just so we can get through this for everyone, okay? So let's talk about the adjudication process, kind of a three-phase process. Right now, we're at step number 4 at the public meeting. The petition, the notice, the summons has all been completed. The next phase is really going to is going to be kind of the boots on the ground phase where we'll send notice out for people to submit claims and they'll have the opportunity to file a claim. For water rights of record, meaning these are water rights that we have upstairs in the file jackets in this large room. Those are what we call water rights of record. If there is no claim filed on that, or if someone fails to file a claim for one of those blue dots, those rights will go on this thing called the list of unclaimed rights, meaning no one has claimed these rights. In essence, what that means is people have just forgotten about them. And that's pretty common, again, in metropolitan Salt Lake Valley, just because people once had wells, then finally Salt Lake City or some public water supplier was able to provide them culinary water. They forgot about their well, and it since was abandoned. And so a lot of these water rights will go on this list of unclaimed rights if there's no claim filed on them. We'll send notice again out of this of this list of unclaimed rights, people have 90 days to file an objection, say, hey, I didn't mean for that right to get on that list of unclaimed rights, I need it to come off, and we'll say, all right, we'll file a claim and we'll address it. If people, if that 90 days expires, what happens is the court decrees that those water rights have been abandoned, meaning no one cares about them, they're lonely, abandoned, and so the court says, hey, these water rights are no longer any good, and we move on to the next phase, which really is where we send our teams out to evaluate any claims that have been filed. So you can file a claim, and our team will come out, and we'll look for the well, we'll look for the head gate, we'll look for the spring box that you claim, and we'll identify the beneficial use associated with that. Then our recommendation will be compiled into the proposed determination. So we'll go out, we'll evaluate, we'll make a recommendation that goes into this proposed determination that gets filed with the court. We'll have another public meeting, and then the court will make a ruling on that. If you don't like what our recommendation is, you have an opportunity to object. I'm going to cover these last few steps that I just covered in greater detail in the next couple of slides. So if you didn't kind of pick up on that, which I kind of sped through it, let's kind of start talking about the step-by-step process. Let's start with filing your water user's claim. So in about a week and a half or 2 weeks from now, you will receive in the mail, if you receive notice of this meeting, you'll receive in the mail a blank claim or a filled out claim. Now, if you're simply a property owner, you'll receive a blank claim. If you're an owner of one of the records or one of the water rights of records, you'll receive a claim that's already filled out with the information we have on file. Okay? And then you have 90 days to fill out that claim form and file it with us or with the court. Again, we don't expect people to be experts at filling out these forms. There's kind of some strange components. Obviously, it's not super intuitive. So we encourage people to call us up or come in. We will fill out the claim with you and help you file it. But you have 90 days to do that. If you can't get it done in 90 days, you can write me and say, hey, I need a 30-day extension before that 90-day period's over, and you have an automatically granted 30-day extension. But if you don't, then you're kind of out of luck. You have to go to the court to get an extension. So I encourage people to, if you have a claim, to kind of get filed within that first 90 days. Those claims that are filed, we will investigate and map. We'll schedule an appointment. So if you put your contact information on the claim, a phone number or an email address, we'll attempt to coordinate in a time and place to come out and meet with you so you can show us your water right. We found it's just a lot easier to work with the public so they can show us how things are being used rather than us trying to guess what you mean by this claim. So his question is, what's the timeline, or how long is it going to take? So when we get a claim, we typically will, we'll get a bunch of claims and we'll kind of work our way through the claims. So when we contact you is kind of undetermined, but once we contact you and make a contact, it's really coming out one day, taking a look around, and then we do a lot of the mapping and stuff like that back here at the office. So it's not a multi-day or a week process to investigate your claim. And more in terms of the whole area, it depends on how many claims we get and how many claims we have to investigate. Usually it's multiple months, if not a year, to go through those. Yes, ma'am. So her question is, based on previous experiences, other adjudications, what percentage of people lost or forfeited a portion or all of their rights because they failed to use their water? Boy, it's a number I don't have a good feel for. I will tell you this, almost 75% of people, of claims on our records in this type of area, people fail to file a claim on. So almost right off the bat, 50 to 75% of the claims go on this list of unclaimed rights because they just aren't being used anymore. No one has an interest in perpetuating them. Of those that are filed, I don't have a great feel for how many of those are forfeited. Again, we try to lean forward in the foxhole as we can on recognizing the fullest extent of the rights as possible. So I don't have a good number for you. Minority, definitely a minority. The minority of people lose their rights. And really, if they're using their water rights, they wouldn't lose them at all. But if there might be some reductions here and there, but for the most part, what we see a lot of is people who had these municipal or these domestic wells who drilled them and they were just simply using for their houses. And then a public water supplier comes in, they connect to the city, but they keep the well and they use it for irrigation. So they don't technically have an authorized right to irrigate with that well, but we simply say, well, they're not using it in an authorized fashion, but because they're using it, it satisfies the need to use it. So we just recognize it and we put a little note saying it's not being used in accordance with how it's authorized, but we're going to recognize it in its entirety. So we get a lot of those. Not a whole lot of water rights are pared down, less than half. I'm not sure. Again, I don't have the number off the top of my head. And maybe Josh or some of my fellow coworkers, some of my staff will have a better feel for how many, because they're that ones actually doing the boots on the ground investigating. So if you can ask them that question, they might have a better feel for it.
It seems like if you have you file a claim and you are using your water, then you're pretty good to go.
Oh yeah, if you file a claim and you're using your water, it's too easy, right? No issue. Like, again, we're not looking to steal water or
I have no idea how much we even use of our.
yeah.
I don't know how much of the water that I actually use.
So yeah, we can look at it, and if you want to come up after, we can talk about your specific scenario and see if we can't put your mind at ease. I mean, honestly, I think if you're using your water, you probably have nothing to worry about, but we can take a look afterwards and try to answer your questions, your specific questions. Okay, let's keep on pushing. So list of unclaimed rights. You'll recall these are all the rights of record, so the ones we have numbers for upstairs in our big filing room. If people fail to file a claim on these go on this unclaimed list, and we'll hold another public meeting like this. You will all receive notice of this list of unclaimed rights, and you'll receive notice of how to access it so you can go down and see if any of them belong to you. And then you have 90 days to file an objection to that list. If you find a water right that says, oh, that's my water right, I don't know how I managed not to file a claim on it, but I just didn't. You file an objection and you file a water user's claim with that objection. You got to file it at the court. That's pretty easy. We don't fight those a whole lot. We just say, okay, big deal, you missed out. I mean, if it's blatantly obvious that you were just being obstinate and failed to file a claim, we might fight it a little bit. But for the most part, we welcome people. We want them to file their claims. So you have 90 days to file an objection with the court. We typically negotiate. And these, again, we pretty much say to the court, hey, we're not going to fight it. Let them have their claim, and we'll evaluate in the proposed determination. Once that 90-day objection period is concluded, the judge will enter a decree and order that it judges that all the rights on that list have been abandoned. And it also prevents any future claims. You remember the Dos Equis guy who was just not filing a claim forever. It prevents him from ever filing a claim in the future. So in essence, this is the time to file a claim if you have a water right that's pre-statutory. Now is the time. If you don't do it, you'll be foreclosed from doing it in the future. Let's talk about the proposed determination. Now, that doesn't mean you can't acquire a right and move it or do something to that effect. You just can't file one of those old diligence claims or the grandfathered rights. So a proposed determination, as you recall, is in essence the accumulation of all of our recommendations into one book. We, again, send notice out. However, this notice will only go to those people who actually filed a claim previously. So if you didn't file a claim, you won't receive notice of that except for in the paper. We'll have a public meeting much like this. People, again, have 90 days to file an objection if they don't like how the state engineer quantified their water right. Let's say we shortchanged them, we didn't give them as much acreage as they thought they deserved. They can file that objection with the district court, and then we simply are required to resolve those objections before the court can issue a decree on that. And usually how that happens is if we made a mistake, we readily admit it, we petition the court to go ahead and amend the proposed determination in favor of the claimant. If it's something we disagree about, then we may litigate it, but it kind of depends on the nature of the objection. Again, the court, in absence of an objection, is obligated to rule on the proposed determination. Just say, it is what it is. The court can't unilaterally say, I don't like what's in here and here, in this or that. They have to have an objection in order to make any other distinction or modification to the proposed determination. So the West Murray Subdivision, there's that same map. You can see that scattering of purple dots. Those are all points of diversion. Most of them are wells. In this boundary, we have 611 water rights of record that we're looking at. Again, probably 50 to 75% of those people won't file claims on just because they're now Walmart parking lots or they're just not being used. We sent out just about 8,500 notices. This is how many people decided to attend the public meeting out of that 8,500. So you can see that the interest level is not as quite as what we'd hoped, but hopefully more people are viewing online. And again, we sent that out to all property owners as well as water right owners. That's why the number is so high. So issues and anticipated timeline. Some of the issues we already kind of talked about: out-of-date title, meaning your address or even the ownership of the water right on our records is not up to date. We encourage people to actively pursue updating that. You don't have to as a part of this. We'll continue to accept your claim regardless of whether you're the owner on our record or not. We'll accept the claim on its face value. You know, if the water right is under the name of the previous homeowner and you file a claim on it, we'll still evaluate it as though you're the owner of the water right. Location of no proof required. Sometimes we abbreviate that as NPR. So during the 40s, 30s and 40s, well 40s, obviously World War II was in full swing. There weren't a lot of engineers or surveyors to certificate where these points of diversion were, which is part of the appropriations process. They'd file a proof and the surveyor or the engineer would come out and say, this is exactly where this point of diversion exists and here's how you tie it back to this section corner. Well, there were a lot of those, and so the legislature said, hey, for a small amount of water, we're just going to allow people to appropriate a water right without having to get it perfected or approved up on by an engineer, which is great. You know, it helped a lot of people out. The problem with it is that the location of where those wells were or those ditches were was never pinned down very well. Forgive the pun. There was never tied to a section corner with precision. As a result, the dots on those maps can be off by hundreds of feet. So you might say, hey, I got this well, it shows right up in my property. I must have a well back there somewhere. That may or may not be the case. Again, those points of diversion have, there's a little bit of, I guess, swing in those depending on where they're at. So as we go out and we evaluate that, that's one of the things we like to tie in is make sure we understand the location of those and we reflect that in the proposed determination. The anticipated timeline, May 2nd, I think, is the date we have for when we're going to send out the notice to file claims. So again, you'll receive a notice as well as a blank claim form if you're a property owner or a claim form filled out with the water right information if you're a water right owner of record. July 31st is when that 90-day claim filing period will conclude. So you'll want to have between May 2nd and July 31st in order to file your claim. November timeframe, we should be publishing the list of unclaimed rights. Again, some of that depends on what type of extensions were requested and granted. February, once that list of unclaimed rights is published, the 90-day period to file an objection begins. February, that will conclude. February 2019, and then we have all these claims to evaluate. So a year later, February 2020 is probably when we're looking at publishing the proposed determination. And we'll probably publish it with a bunch of the other proposed determinations that are going on in the valley right now, just so that if there are objections raised that happen to span different subdivisions, they can be settled at the same time. And then May 2020 is the estimated time frame when that 90-day objection period for the proposed determination will conclude. Yes, ma'am. So our question has to do with federal water rights and what's the true motive and whether it has anything to do with the effort to get state lands, or excuse me, federal lands in state ownership. And truth is no, it has nothing to do with that effort. This predates that effort by 50 years. All its attempts to do is to ensure that the federal government files their claims and quantifies their water rights. Has nothing to do with us taking federal property and turning it into state property. It's just, hey, we have some uncertainty as to what your water rights are, especially in the Forest Service. We have these big claims, and they filed claims. They filed claims, 20 years ago, and it's for an ambiguous amount of water for a lot of different things. And so this is our opportunity to say, hey, we're going to winnow down what the actual needs of the Forest Service are. So it has really nothing to do with that state initiative. Was there another question over here? Yes, ma'am. So her question is, she's lived on this parcel for 20 some odd years. And how does she know that the previous owner didn't have a well and maybe covered it up? How is she to know if there was a well or where it's at? My answer is kind of twofold. First, does it really matter if you haven't used it in the last 7 years? Probably not going to be recognized. But if you're curious nonetheless, we do have records. If they filed something with the state, we can certainly see if there is something there on our records. And I'll show you after this meeting. We have an interface that has aerial imageries that shows where all these historic wells are thought to have been located. So, yes, sir. So the question is, if the proposed determination affects you directly, will you send a notice out to the water right holder? Yes, we will send a notice to either the owner of record on the water right or someone who files a claim on the water right. They will receive notice of the proposed determination. Property owners who don't file claims will not, unlike this notice that brought you all here, the proposed determination notice is only for people who actually filed a claim or demonstrated an interest in knowing the outcome of the proposed determination. So this is, I think, one of the final slides. Will I lose my water right? I think we've answered this in spade in various forms. The bottom line is, if you're using your water right in lines with how it was appropriated and authorized by the city, you have nothing really to worry about. But we do, unless you fail to file a claim on it, all right, within the prescribed time frame. Those individuals who might have some of these older wells that don't have water rights associated with them, we want you to file a claim, but you also probably need to you'll need to show that that well predates 1935, and whether that's because the house existed prior to 1935 and you're still not connected to the culinary system, that's pretty good evidence that the well has been there prior to 1935, and we would look at your claim and probably accept it. Again, if water has not been used for 7 years or more, there's a potential for it to be recommended to be disallowed or a portion of it. So who can I contact to discuss this process? That's me at the top. Gary Brimley is my deputy. He's upstairs working on another proposed determination. He wasn't able to make it tonight. Josh Zimmerman is the bearded gentleman in the green shirt behind you. He's going to be the team leader for this respective subdivision, so it'll be his team in the field. But really, all of us are a team, so if you come in, it may be his team or a different team who helps you file your claim. We all know how to do that, so you don't need to look for him specifically, but most likely one of his team members will be contacting you if you do file a claim to schedule an appointment to come out and look at it. All right, now comes the time for any questions you have. I'm going to look on my email and see if anyone emailed a question in really quick. Doesn't look like anyone did. Oh, you know what?
Are you located here in this building?
Yes, good question. So where are we located? On the second floor of the building, on the west end, Division of Water Rights. You go to the front desk and say adjudication, and they'll know what to do with you, okay? We got a person who sits at the front desk who works specifically for me to help direct your question, your inquiry, okay? Yes, sir. Okay, so the question is, who did we send notice out to? Did we send it out to everyone or just specific people? So you recall that boundary, go back to it right there. We got the records from the state recorder, or the county recorder, excuse me. We got all the land parcel ownership information, and we sent out notice to anyone who owned a parcel within that boundary. So that's why I say property owners, that's what I mean, property owners within that subdivision boundary. But we also sent it out to any owners that we had on our records of water rights that fell within that same boundary. So there's kind of two different categories, and they might be the same. You might be a property owner and have received a blank claim. You might be a water right owner at the same time and received a claim already filled out. So, yes, sir. Mm-hmm. So this question has to do with, they own a water right, they use it, they need to re-drill their well. So when's a good time? Well, first I admonish you, you got to make sure that you are the owner of record on our water rights. If you are, then you simply, I don't know if there's any better time. I guess the good time is when you don't need to use the well, right? Hydrologically speaking, I don't know have any much insight. Oh, no. Sure. No, we'll come out, and again, it's pretty easy to see, to know if a well has been used or not. It's not that hard, especially if you're renovating it. And I mean, our biggest problem is people who don't know they have a water right and have a pipe in their backyard, and they're trying to figure out how to get this pipe to produce water. So when we come out, they can say, yeah, we've been using this for 7 years or whatever. But again, if they do that, hooray for them. But yes, sir. Oh, and I got West Murray up top, don't I? Yes. So I do this, so you can imagine, I don't recreate this entire slide deck every time I do a public meeting. Oh yeah, absolutely. There are, and then I can show you on our web interface. It shows all the bite-sized subdivisions we have going on and what their numbers are and their names. I'll show it to you here in a second. It's a pretty good interface, especially if you just want to use it to print out a USGS map and go camping. It's a great interface. Have nothing to do with water rights, you can still use it. Were there any other questions before I kind of show you how to walk the dog on our website a little bit? All right, then I'm going to go ahead and kind of go off mic a little bit here and start doing some magic web browsing. Hold on. So our website, as you probably saw on our notice, is waterrights.utah.gov. Okay? The easiest way to get to this interface, if you'll notice in the bottom or the right-hand corner, this little map search link, okay? That's the quickest way to get where you want to go. So let's go ahead and hit that. Oh, and see that training videos? That is where this broadcast will be posted. So let's go to the map search. Brings up an aerial imagery overlay. And I'm going to turn off, you'll notice on the right-hand side, you get kind of a menu of items. I'm going to turn off this, the points of diversion off, just because if I don't, you'll see why. It's just a lot of activity in the Salt Lake Valley. So I'm just going to zoom in here. Okay, so this gentleman asked about other blocks or other subdivisions that are going on. So if you look on the right-hand side, you see adjudication books, okay? And if we highlight that, that should populate a bunch of purple lines that will delineate all the subdivisions we have currently going on in the Salt Lake Valley. And because there are a lot of them, it takes a little bit of time. And because I have a slow internet connection, it takes even more. So your question is, can we use the claim form that you receive for this one? Can we use it for other subdivisions? The answer is sure. We'll make it work. The problem is the form you receive will have a specific book and area number, so it might kind of confuse us a little bit as to what you're trying to file a claim on, especially if you do it at a later date, because we're going to say, hey, this area is already closed. But if you say, but we have a blank form online that you can use as well. So you'll see all of these purple areas, right? So we're kind of we started here, 57.2, and kind of worked up to the north side of the valley. Kind of start up here, and then we're kind of making our way back down and heading back down towards the south end on the east side of the valley. So let's zoom in on the East Murray book. You see their number. So 57 is the division number, 20 is the book number or subdivision number. I'm going to zoom in just a little bit more. And I'm going to go over here to points of diversion, and I'm going to select it. And it's going to blow up with a bunch of wells everywhere. Okay. So the red icons are wells. The blue icons represent surface points of diversion. All right. And so there's some other features on this. If you want to use different maps over here on these tabs, you can do topo maps, you can do Google imagery, whatever you want to use. So I usually like to use the Google imagery because I think it's better quality. There's also a search. So if you want to search for a specific water right number, you can put it in here. Or you can even punch in, if you're not really good at navigating to your address here, you can go down here and select address. All right, someone give me an address they want me to look up. 185 East. What's that? Vine Street. And I know you're not Salt Lake City, but it's just easier to put SLC because it'll get me the same spot. So it'll zoom in. So the red X represents the address location. But you can see 576690 appears to be a well location for a water right. And you can select, you can hover over that and select it, and it'll bring up some information. From this information, there's some codes that probably don't mean much to you, but I can kind of interpret them using the Rosetta Stone here. That's the water right number. UGWC means it's an underground water claim. That means it was drilled prior to 1935, and they filed a kind of a diligence claim or a grandfathered claim on it. This is the name of the person who filed it, Meddy C. Davis. That's the location. And so what this means is it's a location with respect to the nearest section corner, and a section using the public land survey system. So this is south 1,440 feet, east 1,500 feet from the northwest corner of section 7, range 2 south, township 1 east, Salt Lake City Basin Meridian, okay? Or township. I can never remember range and township. I get those mixed up sometimes. But if you select the water right number at the top, so you see there's a hyperlink right here under the water right number. If you select that, this brings up our web page, which will show the database that we have for the water right. This shows all the information associated with this respective water right. So I'm going to just kind of pan down a little bit. Again, we have the, oh shoot, you guys. When did they file that? I can show that to you. Yeah, it's what I need to do is just do this. Close enough, right? So I'll show you how to find some interesting information. So right here, here's Nettie Davis, or Meddy Davis, the address. It was filed in 1938. It has a priority date of 1905, meaning that's when the well was first drilled. It's an underground water claim. It's for 0.033 cubic feet per second. It was used for, down here, water use, irrigation of 0.13 acres, 4 stock units. Sometimes we call those ELUs, or equivalent livestock units. So in essence, 4 headed stock, or 4 horses, 4 cows, and 1.6 EDUs. Really what that means is it's used for 1 house. It was, in essence, it was a house with probably like 8 people in it. And there was a conversion that happened a long time ago where they said, well, we're just going to say a house is 5 people, so we'll just divide 8 by 5 and get 1.6. But in reality, it's just for 1 house. And then this is the location of it down here. It's in the southeast quarter of the northwest quarter of Section 7. So what you may be interested in to find out more information, there's a little drop-down box right here, and you hit Scanned Documents, okay? You go to Scanned Documents. These are all the documents that we have in the file upstairs, including the original underground water claim. We can select on that, and it'll bring up the scanned document of the old water claim that was originally filed by Meddy Davis, okay? With all the original chicken scratching and everything. And there's probably some other data and information along those lines. So this is a valuable resource for you to conduct your own investigation in and around your property. If you're not sure if you have a water right, or if you have a well in your property and you don't know what the water right number is, or how to find out more information, this is a great place to go. Remember, keep in mind that your well might be in the back corner of your lot, but there's a water right in the neighbor's yard. That might still be the water right for that well. It just has a bad location due to those no proofs required, plus the modern advent of GIS, trying to rectify the aerial imagery with the public land survey system. So there's a couple of factors that might mean that this well truly probably isn't in the middle of their driveway. It might be over here or something like that, okay? The imagery, this shows it as 2017, June 2017. So it depends on whatever, we're just a consumer of whatever imagery Google provides or the state provides. So, are there any questions with respect to this? Anyone want to look up their address or anything else? Or I'm happy to do your address, you betcha. What's the address? Let me just get rid of it. Oh, okay. That's correct? So there's your house. We can zoom out a little bit, see if there's anything else nearby. We have, shows there's this one here, Thomas Strange. So there you have it. Oops. Yeah, and I know in this area there's some old irrigation companies that they may be diverting out of like Big Cottonwood Canyon, Big Cottonwood Creek, which is. It would only show, so the point of diversion that we would show is where the water is removed from the natural source. And so it would be somewhere on Big Cottonwood Creek if that's where the water is coming from. So what you're describing is you have the natural stream with the main head gate off the stream, and that's what we would call the point of diversion. Then you have a series of canals, ditches, and laterals, which wouldn't necessarily have points of diversion associated with them on our records, because we're only worried about where the water is diverted away from the natural source. So that's why it may not show up here. If we panned out and kind of panned over to Big Cottonwood, you probably see some blue icons, which would indicate surface diversions. Yeah. So like this one over here, William Baker. That's for the Godfrey Pond Springs. It looks like that's a pretty old water right, I can tell, because it's got a low number. And it has a priority date of 1932, and it's an application. So it's kind of an older application. You don't often see many of those. Yeah. So anyhow. Yeah. You can go anywhere in the state and look at this. I just, as you kind of zoom out, it just becomes cumbersome to look at it'll only show so many water rights, but it takes longer. So I usually turn off that layer. Otherwise, it just becomes incomprehensible, right? Who's your ditch company? Walker Ditch? Yeah, sure. I would. I know we've talked with Walker Ditch. Are you trying to raise me, Paul? Yes, sir. Oh, yeah. Thank you. Paul's ever so mindful of. All right. So if we go to the main website, I'm just going to go back. But yeah, I would contact the ditch company. I know I've heard about Walker Ditch. Do we need to contact the company and get them apprised of this? Yeah, I know we've talked Walker Ditch, because Walker Ditch, I believe, is in the original decree, the original Big Cottonwood Creek decree, if I recall correctly. But Josh and my staff would be much more intimately aware. Again, I supervise the program, which is a statewide program, and these guys are the teams for these individual subdivisions. But I know we've talked some of these decrees. So let's go to the forms, okay? So if you go to, hopefully I can find the right spot. Oh, applications forms. So over here in this resources field over here, applications and forms, and they stuck us way down at the bottom. So you go past new applications, proof applications, and you go to adjudication forms. Here's a blank water users claim form. If you want to file an extension request to file a claim, there's a form for that. Or you can simply email me at the address in the presentation, and I'll use that as well. And then if you're interested in documenting a water right that's not of record, meaning it's a pre-statutory right, meaning it's prior to 1935 for your for an underground water right, or it's prior to 1903 for a surface water right, this form will kind of give you an idea of some of the documentation requirements to do that when you file your claim. Oh yeah, that's here. It's up here. Thanks for reminding me about that. Let's see if you guys see it before I do. Okay, yeah, right there. Yeah. So if you do that, let's see I think it'll probably come up with a form filler application. Yeah. So you just write your water right number in there, and then I'll walk you through the process of doing that. Okay.
Thank you, Blake.
Yeah, my pleasure. Any other questions? Happy to talk one-on-one if you have some specific issues you'd like to discuss. But otherwise, thank you for your attendance. Not all the way, no.